Papua New Guinea's resources have been extracted over the years by foreign mining and petroleum companies. The oil and gas laws allows the state to own the resources, while customary landowners are paid some form of compensation in terms of royalties, equities and spin of businesses. But over the years, there have always been issues over land ownership, with countless court battles to identify genuine landowners. It is argued that clan vetting and landowner identification were not carried prior to the operation of the LNG project, and that has caused a lot of resentments over the years.
One them respond by you give him black. When by you pay me black. By you welcome now, me black asking company to frustration because I'm better right from black.
And I love here. And before Farablo been working houseman land up here, and up in triple tanker and up here. Now Tamblo, one player has enough staff Tamblo, yeah. House Mary.
A landowner who has stood out to challenge this unfairness is Simon Ekanda, a leader of the Tugiba tribe, which owns 1/3 of where the project site is situated.
The LNG project is still an illegal project because the Tugiba tribe, which I'm the chairman, has not given its consent and to the project and to ExxonMobil to come exit to our private property in the tribal land of the Tugiba tribe.
Mibla sabe also ground is tabla hand whether Mibla walking bet rights from blood straight. I mean hard law. Question me no some people court, no some people cross. I'm straightforward.
Mr. Ekanda, after many years of court battle advocating for land rights, recently pursued a constitutional reference on the legality of amendments to certain provisions of the Constitution and the Oil and Gas Act. The constitutional reference was to determine issues relating to ownership of natural resources, such as oil and gas in the country. The application was filed pursuant to Section 18 of the Constitution for a full Supreme Court bench to interpret and determine several questions relating to the legality of certain provisions of the Constitution and the Oil and Gas Act. Mr. Ekanda, as the applicant, asked the court to interpret Sections 53 and 212 of the Constitution and Section 6 of the Oil and Gas Act. These provisions basically give the state the right to own hydrocarbons and minerals in their natural state in any land in Papua New Guinea. Section 6 of the Oil and Gas Act provides that all petroleum and helium at all below the surface of any lands is, and shall be deemed at all times, to have been the property of the state. Mr. Ekanda argued that there were flaws in the laws where provisions of the Oil and Gas Act was not consistent with provisions of the Constitution in terms of resource ownership. He argued that Section 53 and 212 of the Constitution was in conflict with Section 6 of the Oil and Gas Act, and he therefore wanted the Supreme Court to have those provisions interpreted correctly to fairly recognize the traditional and customary landowners of the resource areas. However, the Supreme Court found that Mr. Ekanda had no standing to pursue the reference and also recommended that the matter be reverted to the land court. Mr. Ekanda respected the court outcome and vowed to prove his standing in the land court and returned to the higher courts to pursue the merits of his case.
What I pleaded for in the Supreme Court was to give me interpretations on Section 53 against Section 212 of the Constitution that denies my rights to ownership. As me representing the Hela Tugiba tribe, which we have already owned by custom, because of my pleading in the Supreme Court was to interpret the laws, the flaws of the laws that has denied Section 53 and Section 212. Also doesn't agree with Section 6 of the Oil and Gas Act to ownership. I claim the ownership as a Hela nation, as a nation of Hela. We own it by custom, and we've been trading it. And Hagen is our buyer, Medi is our buyer, the Angans are our buyer. We've been selling this for time immemorial. Our fathers were doing that. It was already a business trade, and we got a name to it. our fathers were already scientists, explored the use of oil. And we got a name to it. We call it bagua. The bagua has got the light crude oil was called aminan, but the crude oil was called bagoyara. And we own it. How in the world they took away my ownership from my tribe and vested onto the state is the one that I challenged that has been provided for me by Section 53 of the Constitution, which I have already challenged in 2012, knowing very well I was challenging them in the same Supreme Court under the different rule with Ambassador Peter Donigi as a constitutional lawyer. We did it under the separate rule, so we were sent back to file the same application in the appropriate rules. Now, knowing very well the state has decided to block me in 2016 by inserting an amendment to Section 212, purposely to block my Hela nation to take an ownership of the oil that was already been producing by culture, by custom, given by the creator himself. We call it Tatakari Wabe. And it's not a new product, it's a very old product. My fathers, which I have fired, has rejected the white colonists who came into my country, into my nation. It's recorded in the book called Papua New Guinea by Jac West, that he wrote, I quote, "The people were already civilized. Now, we gave them eggs, they reject our eggs. We gave them salt, they reject our salt because they had their salt. We give them matches, light them up, they made the light with the traditional light. And then we were given a robe of sweet potato and sent us away, which means our fathers didn't accept the white bribery to deprive our rights and our governance to our culture. Now, my fathers did that. Now, when they did that, the sons has already did. We protested in Kokopo not to participate because we owned it, because our ownership was not accommodated in that agreement in Kokopo, in UBSA, LBSA. No, we are never signatories to that until today. We are still, I am going to announce this one on record. We are going to still own the ownership of the resources that we owned it before the Western culture was introduced to us. We were already civilized. My fathers were already civilized. We were already scientists. They came to brainwash us, to make us think that we don't own what we have. And that is the fight that I'm fighting today. In the laws that we have adopted has denied my rights to own my property, which is already provided by Section 53 of the Constitution. Did an amendment to block me in Section 212. And also, Section 212 promotes the deprivation of my rights in Section 6 of the Oil and Gas Act. And I close my chapter today in the Supreme Court challenge, and I will honor the decision by me going back to the District Land Court. And if that allows me to come back, I'm coming back. The whole Hela nation will come back. And we will not settle for less on our ownership that we've been owning and we've been producing. And we got evidence to our property rights. That has never been tried in the substantive matter. They kicked me out at the door. Which means the law that is in today governing this country doesn't recognize my existence. This is about existence. They don't know Mr. Ekanda exists. That's why they don't know me. They said, okay, Mr. Ekanda, go back to land court to identify yourself. Do I have to prove myself to anyone else? No. I exist in this country. I exist in my nation, in my Hela nation. And I will not settle for less. Thank you, Papua New Guinea.